Welcome to literary and jury charge practice. Let's start out with some literary. This is called A Question of Choice. Ready? Here we go. As with many technical advances, increased connectivity has its pros and cons. All this information can be really positive for both society and individuals, says John Nielsen, AAA's Managing Director of Automotive Engineering and Repair. It can help keep you safe by telling you your car's tire pressure is low. It can prevent a breakdown by letting you know your car's alternator is failing, and it can save you money by helping you maintain your car better. But it also raises concerns because in most cases there's no way for you, the consumer, to limit or control who has access to the personal information or vehicle data your gas card generates. You can turn off the cookies or GPS functions on a laptop or smartphone if you don't want to be tracked on those devices. That level of control isn't available in a car, says Nate Cardozo, a staff attorney with the Electronic Frontier Foundation, a San Francisco-based consumer watchdog group. Should it be? To date, automakers haven't been required to provide options or information to consumers. Some car companies have data about your vehicle and also your driving habits, including, for example, how fast you drive and your car's location at any given time. Consumers should have the right to know who's getting data from their vehicle and what choices they have about how it's used, AAA's Nielsen says. As vehicles become more sophisticated and collect and transmit more data, the consumer's choices and options need to keep pace. All right, now for this closing argument. Ready? Here we go. Now, he testified that he had to work the day of this accident, but that he had to be at work at 2. Accident happened at 2 in the afternoon, and he was only about a quarter mile from his house. So Mr. Irvin had no reason to be in a hurry. He had no reason to try to pass this vehicle because no matter what he did, he was gonna be home in 5 minutes. Either way, all he had to do was make it to the light, turn left, and then turn right away. He wasn't trying to pass the vehicle. Nobody's testified that he was. When you have these kinds of questions, what you need to do is you need to decide if Mr. Irvin has shown you more likely than not that a Baltimore Tank Lines vehicle came into his lane and caused the accident. Now, you're going to also have to look at, when Mr. Irvin was cross-examined, he got asked a lot of questions about distances and exactly where he was, and you saw the manner in which he answered those questions. He was straightforward. Mr. Irvin wasn't trying to say that his testimony at deposition was anything other than what it was, or that he really changed what he testified about. All he said is that he had to estimate the distances because he's not an engineer and he didn't have access to the exact measurements, but that when he did have a chance to look at the diagrams that were produced, he did the best he could to illustrate for you what happened. Now, Mr. Irvin never told you that everything he has shown you on this diagram is exact to the foot and inch, but what he did do is is he did use the diagram to show you what happened, and just like he testified, what he has here is he's got his vehicle, the Honda, and it's established in his turn lane. He's already driving in that lane when the tractor trailer comes over into his lane. Now, he said his brother worked for Baltimore Tank Lines, so he knew what their trucks look like, and more importantly, he knew that Baltimore Tank Lines hauls oil. Everybody knows that oil is dangerous. Everybody knows that a tractor trailer with an oil tanker on it is dangerous because in addition to the regular danger that you would have from any kind of a collision with a big vehicle like a tractor trailer, you've also got the added fire or explosion danger if that tanker had something in it. And what Mr. Irvin said he did is he did, and again we're back to the instructions that the judge gave. He did what a reasonable person would have done. He was traveling at a constant speed in his turn lane when a very large vehicle that he thought was full of a flammable liquid came over. He did what a reasonable person would do, which is he went in the opposite direction of that oil tanker as quickly as he could, because he knew that it presented an immediate danger to him. And he testified that he didn't have time to see what was in the other lane because of the danger. And what the judge told you about evaluating whether somebody was reasonable or not is that you have to look at the reasonableness of what they did in light of the situation that they were in. And Mr. Irvin was in a situation where a large, dangerous vehicle came into his lane, and he had to decide the best thing to do right away, like that. He didn't have time to sit and think about it, so he did what a reasonable person would do. He steered to the left in the opposite direction as quickly as he could. Now it turns out that there was another vehicle in that lane. Mr. Young is in the unfortunate position of being a party to this because she happened to be driving one of the cars that was involved in this accident. You're gonna have to determine whether there's something she could have done to have avoided the accident. I can't guide you on that. You're going to have to make that decision based on looking at her testimony. And again, Ms. Young doesn't tell us anything about how the accident happened, but she does tell us a few things that are important. Mr. Young, Ms. Young, Mr. Irvin, the main thing that he told you was this truck came over into his lane all of a sudden, and he had to get away from it. Now you can see that the distance where his truck is along the side of this tractor trailer, it looks like a different position here than it does there. And again, he testified that he didn't measure it out. He gave his best estimate, but what he is sure about is that he was somewhere in the middle of this tractor trailer because it's closer to the front of it or closer to the back of it. But either way, his car was next to this tanker as it came over into his lane, and he testified to you that the first thing he said to Ms. Young when he talked to her at the scene was, "Did you see the truck that just cut me off?" And when I talked to Ms. Young, the main thing that I really wanted to get across to you folks is that she backed up what Mr. Irvin said. I asked her flat out, isn't it true that the first thing he said to you was, "Did you see the tractor trailer that cut me off?" And she admitted that that is exactly what he had said. Mr. Irvin said the same thing to the police when they showed up. "A tractor trailer cut me off." All right, now for some jury charge practice. Ready? Here we go. I will now describe the standards you must apply in determining whether to award Ms. Bovang punitive damages. If you find in Ms. Bovang's favor on either her quid pro quo sexual harassment claim or her retaliation claim under the New York City human rights law, you may but are not required to award punitive damages on either or both of those claims. To establish her entitlement to punitive damages under the city human rights law, Ms. Bovang must show by a preponderance of the evidence that the defendant you are considering acted with malice or with reckless indifference to Ms. Bovang's rights. For purpose of a quid pro quo sexual harassment claim or retaliation claim under the city human rights law, a defendant acts with malice or reckless indifference where the defendant knew that his or its conduct violated the law prohibiting gender discrimination or retaliation, or acted with reckless disregard of the law. Direct evidence that a defendant acts with knowledge that the discrimination or retaliation violated the law is not required. Rather, the requisite state of mind may be inferred from the circumstances. Additionally, even if Ms. Bovang does not prove that a defendant knew he or it was acting in violation of the law, you may infer that a defendant acted with malice if you find that he or it acted outrageously. If you find in Ms. Bovang's favor on either her assault or battery claim, you may, but are not required to, award punitive damages on either or both of those claims. To establish her entitlement to punitive damages on her assault and battery claims, Ms. Bovang must prove by a preponderance of the evidence that Mr. Way's actions were intentional and deliberate, and that they have the character of outrage frequently associated with crime. You must find that Mr. Way acted with spite or malice, or with an evil motive, or with a willful, wanton, or deliberate disregard of Ms. Bovang's rights and interests. Finally, if you find in Ms. Bovang's favor on her defamation claim, you may, but are not required to, award punitive damages on that claim. To establish her entitlement to punitive damages on her defamation claim, Ms. Bovang must prove by a preponderance of the evidence that the defendant you are considering acted with malice in making a defamatory statement about plaintiff. A statement is made maliciously if it is made with deliberate intent to injure, or made out of hatred, ill will, or spite, or made with willful, wanton, or reckless disregard of Ms. Bovang's rights. To determine whether a defendant acted with malice in making a defamatory statement concerning Ms. Bovang, you may consider all of the relevant circumstances surrounding the making of the statement, including prior or subsequent defamatory statements, other statements made by the defendant, and evidence of a defendant's ill will or hostility towards Ms. Bovang. If the natural inference from the defamatory statement itself is that it was aimed directly at attacking Ms. Bovang's reputation, you may find that the defendant who made the statement acted with malice. If you decide that Ms. Bovang has met her burden of proving an entitlement to punitive damages on any of her claims, you are not to specify what dollar amount you believe proper. That will be addressed by you later. Now you must only decide whether Ms. Bovang is entitled to an award of punitive damages. Ladies and gentlemen of the jury, that concludes my instructions to you concerning the specific claims in this case. You will soon retire to the jury room and begin your deliberations. All of the exhibits that were admitted into evidence during the trial will be sent into the jury room other than the tape recordings. If you want any of the testimony read back to you, you may request that. If you want any of the audio or videotape played again, you may also request that. Please remember that it is not always easy to locate what you might want, so be as specific as you possibly can in requesting exhibits or portions of the testimony. If you want any further explanation of the law as I have explained it to you, you may also request that. As I noted earlier, however, you will each be permitted to take your copy of the instructions into the jury room. Any communication to me should be made in writing signed by your foreperson, include the date and time, and be given to one of the marshals. Please make any notes as clear and precise as possible. Do not tell me or anyone else how the jury stands on any issue until after a unanimous verdict is reached. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement. Each of you must decide the case for himself or herself, but you should do so only after a consideration of the case with your fellow jurors, and you should not hesitate to change an opinion when convinced that it is erroneous. Discuss and weigh your respective opinions dispassionately without regard to sympathy, without regard to prejudice or favor for either side, and adopt that conclusion which in your good conscience appears to be most in accordance with the truth. Your verdict must be unanimous, but you are not bound to surrender your honest convictions concerning the effect or weight of the evidence for the mere purpose of returning a verdict or solely because of the opinion of other jurors. Each of you must make your own decision about the proper outcome of this case based on your consideration of the evidence and your discussions with your fellow jurors. No juror should surrender his or her beliefs solely for the purpose of returning a unanimous verdict. If you are divided, do not report how the vote stands, and if you have reached a verdict, do not report what it is until you are asked in open court. Your verdict will be organized according to a verdict form. This form will assist you in reaching a verdict and lists the questions you must answer based on the instructions that I have given. Finally, I referred a moment ago to a foreperson. It is customary for juror number 1 to serve as the foreperson, and that is what we will do here. The foreperson doesn't have any more power or authority than any other juror, and his vote or opinion doesn't count for any more than any other juror's vote or opinion. The foreperson is merely your spokesperson to the court. He will send out any notes, and when the jury has reached a verdict, he will notify the marshal that the jury has reached a verdict, and you will come into open court and deliver your verdict. After you have reached a verdict, your foreperson will fill in the form that has been given to you, sign and date it, and advise the marshal outside your door that you are ready to return to the courtroom. Each of you must be in agreement with the verdict that is announced in court. Once your verdict is announced by your foreperson in open court and officially recorded, it cannot ordinarily be revoked. Members of the jury, that concludes my instructions to you. I will ask you to remain seated while I confer with the attorneys to see if there are any additional instructions that they would like me to give. The marshal will now be sworn. Members of the jury, you may now begin your deliberations. All right, that was good timing. That will conclude our literary and jury charge practice.